Welcome back to the video lecture on East Asian state leadership in international law. This particular lecture is devoted to the specific cases related to East Asian states leadership in international law. The first case will discuss that the prioritization of national interests and need to identify international law in a case of the Korea. Inherently limited by its historical and geopolitical factors, the Korea is focused to rely on the interpretation and application of international law. From the Korea-Japan's relations, for example, which result from the Japanese occupation of Korea, and also inter-Korean and Korea-US relations that were established before and after the division of the Korean Peninsula and Korean War, and the Korea-China relations that is becoming increasingly important with the rising economic dependencies and as a reflection of the security situation of East Asia, the stable management of the highly mobile, the bilateral relations is very challenging that is directly related to the survival of the country. Furthermore, as a member of the international community, including United Nations, the Korea's accurate interpretation and application of international laws regarding multilateral relations is an important issue. Then, in the face of such complex national interests, what do we have to do? The first, what are the standards and directions adopted by Korea for the interpretation and application of international law? And second, and have policy alternatives been appropriately formed? And third, going further, can Korea lead international legal norms? Let me touch upon the couple of issues based on which I mentioned to you. The biggest international legal issues that Korea may face in the next 6 months will most likely arise from the Korea-Japan's relations. Currently, to resolve the issues of the compensation of the Korea victims of the forced labor during the Japanese occupation, both countries have been collecting opinions on the victims, the implementation of the Supreme Court decisions and law courts, and the measures Japan has undertaken in response, all of which has become the basis for the process of the resolution. However, it is very difficult to predict when a settlement will occur. Furthermore, there is even a possibility that the Korea government's countermeasures against the disposal of the contaminated water from Japan's Fukushima nuclear power plant, which was already started the August of this last year, may affect the interpretation and application of the factually and regionally unrelated 1965 the Korea-Japan's claim, the settlement, the agreement. Fundamentally, not all complex issues between Korea and Japan are interlinked, and when such a correlation is lacking, excessive consideration for the diplomatic relations is unnecessary. However, the pending international legal issues between states may be relevant since the resolution proceedings may be extremely impactful. If the forced labor, for example, issues is not diplomatically resolved by a scheduled disposal of the contaminated water by this year, the Korea government may or will have to choose the best course of action to navigate through the following political dilemma. The first, when Japan disposes the process of the Fukushima contaminated water, Korea can argue that this constitutes a violation of international law and commands the arbitral action or litigation against Japan, while requesting provisional measures from for example, International Tribunal for the Law of the Sea. For the provisional measure, Korea bears the burden of proof to show that its rights are under imminent and serious harm. Legally, even if a provisional measure is granted in favor of Korea and the disposal is suspended temporarily, it is unlikely that arbitrary tribunals, the authority over the matters of contaminated water disposal, will be recognized. Even if such authority was established, since Korea suffered no tangible damages due to disposal, Japan will not be held legally liable. In conclusion, given the uncertainty of the court judgment, arbitrary action would be an option that is purely for policy reasons. And while the government claimed that the disposal of contaminated water will damage the marine environment, would have a significant impact for the domestic distribution and consumption of the seafood, how the government overcomes the potentially negative trial result is an entirely different matter. The second, for example, one of the important issues between two states for the so-called the restoration of the Korea-Japan's relations, the Korea can maintain its current policy direction. Taking into consideration the position of the United States and the International Atomic Energy Agency, Korea can respond by expressing its diplomatic dissatisfaction over Japan's discharge of the contaminated water. Although it is uncertain whether this would be helpful for the diplomatic relations of the issue regarding compensation for the victims of the forced labor during Japan's colonial era, it will bring about a great political confusion domestically. The aggressive resistance from the domestic fisheries, environmental organizations, and related local governments will also need to be addressed, along with the issues of the appropriate compensation. Furthermore, the government would need to explain its reasons for contradicting the WTO, the World Trade Organization, body's decision in 2019, which approved Korea's regulatory practice for imported fisheries products from Fukushima. Media report has already politicized the Japanese government's recent demand for the abolition of Korea's restriction on imported seafood. Unfortunately, given the difficulty of providing causal link between the discharge of the contaminated water and the detection of the radioactivity, the pollutants in Korean waters, the Korean government attempts to hold the Japan's legally responsible for the scheduled disposal of the Fukushima nuclear power plants are unlikely to be successful. Moreover, given Korea's limited experience with the international litigation outside of the international trade, the lawsuit against Japan would not be a fair playing the field, especially with Japan's more extensive experience with the international litigation. At the same time, it would be difficult to gain the public's understanding if no countermeasures are taken against Japan's disposal of contaminated water, since inaction can be seen as a dereliction of the government's duty. Without plausible third option in sight, it will be interesting to see how the Korean government escaped this policy dilemma. The United Nations Convention on the Law of the Sea obligates its contracting states to protect and conserve the marine environment. However, rather than being binding and compulsory, the UNCLOS is composed of the general provisions and recommendations. As such, for the effective execution of the Convention, its provision must be amended based on the international treaties and domestic laws. It is also important to note that the UNCLOS not only considers the protection of the marine environment to be of interest to the international community as a whole, but also stipulates that the protection and preservation of the marine environment in high seas fall under the general obligation of a state. Accordingly, all countries must cooperate at the global and regional level to preserve the marine environment. A joint litigation with the Pacific Islands, with their high interest in issues regarding marine environment, is an option to consider at this moment as well. In line with this, there are three other factors must be taken into consideration. The first, for technical and scientific reasons, Japan may delay the disposal of the contaminated water. However, it would be futile to expect Japan to adjust the scheduled disposal for the sake of Korea and Japan's diplomatic relations. Japan will regard the two matters separately and will proceed with their respective schedules. Similarly, the Korea must, in principle, respond and resolve each issue separately and accordingly. The second, an understanding of Japan's implementation of the international law is necessary. Japan is a model example of a country that avoids taking responsibility by complying with the minimally required standard of international law, an action which is clearly void of a necessary normative justification. This also means that, given Japan's limited implementation and application of international law, it cannot be a leading state for international law. Unlike its neighboring countries, Korea is the only East Asian country to periodically undergo regime changes through a democratic process. This is a very great national asset as it provides the foundation for survival amidst the rapidly challenging global political environment and major powers. As a country whose foreign policy is based more on bilateral diplomacy rather than multilateral diplomacy, for the best utilization of its asset, Korea needs to gain a clear perception of the differences between domestic law and domestic politics and international law and international politics. Since the regime can always change, domestic politics and domestic legal standard should not be the basis of the judgment for the foreign relations established based on the foreign policy of the particular regime. In other words, any attempt to change existing foreign relations deformed by the international law after regime change require very careful review. For the diplomatic resolution of the Japanese colonial era forced labor issue and the development of the responsive measures against Japan's disposal of the contaminated water, the current Korean government must determine whether the maintenance or disturbance of the existing Korea-Japan's relations will better serve the national interest. With the rapidly challenging East Asian political climate and Korea-Japan's relations, Korea's approach to international law must be better established. Thank you very much for your attention.